Since Monday, he has shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times.
Right. You just told me, or you told the bailiff to tell me that I had to exercise a right that I should already have. I did that. Not once, not twice, 3 times. And it still wasn't honored.
Up with the commentary.
No, I'm going to say what I want.
You called this witness. I'm going to take a break right now and excuse the jury and this witness.
All right.
What you doing is judicial misconduct. Judicial misconduct. You don't call yourself a judge as much as bias you could put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. Just do what you got to do so I can get up out of here. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a judge?
Brooks, I need to make a record of
I need to make a record too.
You don't.
When am I going to get the chance to do that?
At the
end of the day,
let him finish.
If we're going to open the door on that.
Brooks.
No, since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Once
so
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can
loud,
open the door on how old she told me she
disrespectful,
was.
interrupting.
We can ask that question
he is
too. Then
over the top, animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state finish.
No, I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right.
He has been repeatedly kicked out of the courtroom. In fact, he's spending the majority of his time outside of the courtroom in that adjacent courtroom.
So for the people who aren't familiar with Darrell Brooks, I'm going to be playing a news clip for you guys. This is him. Let's check this out real quick, just to give you guys a refresher.
Well, all eyes are on Milwaukee tonight. Tomorrow they're going to be on Waukesha County, and that's where the trial against Darrell Brooks will begin, with the defendant representing himself.
Brooks is charged with killing 6 people at the Waukesha Christmas parade last year. Bill Miston takes a look back at what got us to this point.
Okay, let me pause it real quick to inform you guys. He chose to fire his 2 attorneys at his preliminary hearing, and he decided to defend himself or represent himself in court. That's where all the madness starts, because we all know from past experience, the people that decide to represent themselves are usually very narcissistic, crazy, insane, just don't have it all. So he's decided to represent himself. But let's continue. Guys, whoever decided to click on my video, I just want to ask you to give me some grace. This is my 5th or 6th time editing. I just learned how to edit videos last Saturday. I just started making videos last Saturday. I'm not perfect. I have anxiety. I'm very shy. I'm very introverted. This is not the norm for me. I'm not a YouTuber, Twitcher, anything like that. So please excuse and forgive my mannerisms. I know I rock back and forth a lot when I'm nervous, or I say or but or a lot. Rewatching these videos and editing them, I'm realizing a lot of things about myself that I didn't even know about myself. Because I used to hear people say a lot, and I'm like, why do they say so much? And now here I am. And I mean, I have no script. I have no one helping me do these things. This is just me. This is just you and me here. So please give me some grace. It's not gonna be a perfect video. I'm not here to be perfect. I'm here to be me. When I started making this video, I had a lot of different ideas for it. So I'm going to incorporate some of those ideas in the next few videos. So if this video seemed kind of watered down, it's just my first time. Just give me grace. I'm learning. I'm recording. I'm editing. I'm finding my own GIFs, title, clips, snips. I'm doing all this by myself in YouTube and ChatGPT and searching, just Googling, you know, like it's a lot of time, a lot of effort. But as I said, please give me grace. And like I said, another thing I want to grow with you guys. As I grow, I want you to grow. If you have a page that you just started, leave it in the comments. I'll follow it. Let's follow each other. Let's help each other. Let's support each other. And in 2026, it is January 1st. Um, let's give each other grace. Okay. Thank you.
November 21st, 2021, 4 p.m. The Waukesha Christmas Parade kicked off. It started here at East Main and White Rock. Parade goers lined the route. But about 30 minutes after the parade started, calls started to come in. Less than a minute later,
Look at that. Y'all saw how fast he was going on a parade route. He nearly hit that girl. Mind you, he hit at least 60 people. There's videos online that is so tragic. I did see it on Twitter when it happened 3 years ago. Someone was like on the 5th floor recording, and like the people were just like getting mowed over like bowling pins. It was crazy. Look how fast he was going.
less than a minute later,
Look at that compared to the truck. Just think about it. Look at it.
Where the subjects are that are claiming that this fight happened.
less than a minute later,
Maroon
my
Ford
God.
escapes with blue White Rock and Hartwell heading into the parade route. I escaped last mail. I couldn't stop it. He's going left stop, blowing his horn.
as the red SUV
Oh my God, this is the footage. I can't believe they showing it. Oh my God, guys, just buckle up. Just buckle up.
approached West Main in Wisconsin,
Oh.
running people over.
I'm so glad they didn't show it. I couldn't believe. I was like, oh my God, are they about to show this? This is the video I saw on Twitter. It would. I'm speechless 3 years later. I can only imagine.
As the red SUV approached West Main in Wisconsin, running people over, witnesses said it appeared to be zigzagging, avoiding cars, but not people. 6 people were killed, dozens injured in mere minutes. The car was later found not far away, abandoned in a backyard off of Maple. The driver, Darrell Brooks, was found a half-mile away, knocking on a door. Days later. Bill Miston, Fox 6 News.
That is crazy, y'all. I have like chills. I literally have chills going down my spine right now. I was not there. I was not one of the victims. I was not related, but that doesn't mean you don't have to show empathy. Like, it literally feels like I was there. Just thinking about, like I said, I watched the trial multiple times. I watched his interrogation multiple times. Let me know in the comments if you guys want me to go over his interrogation with you guys. But it was a sad situation all around. 6 counts of first-degree intentional homicide, 61 counts of first-degree recklessly endangering safety with a dangerous weapon, which is the vehicle. 6 counts of hit and run causing death. So Darrell was charged with allegedly, mind you, he's been convicted and sentenced, allegedly driving a SUV, his mother's SUV, into a crowd at the parade November 21st, 2021, killing 6 people. He has 6 counts of first-degree intentional homicide, 61 counts of first-degree recklessly endangering safety, using a dangerous weapon, which was the SUV, and then 6 counts of hit and run causing death, 2 counts of felony bail jumping. If you guys have watched the trial, he was like literally out of jail for at least a week after previously running over his girlfriend, breaking her leg like a week ago with the same SUV. His mom bailed him out. The judge let him out. Mind you, he had like so many prior charges and things like that. They still let him out, and a week later he killed all these people and injured all these people. He had misdemeanor domestic abuse because he did put his hands and physically harm his ex-girlfriend, as well as, like I said, hit her with his mom's car. In total, he had 76 to 77 counts that was tied to this incident. He was convicted. The jury found him guilty on all 76 counts. October 2022, I was there to watch the trial on Law and Crown Network. I was in the comments. If you rewatch the trial today and you look at the comments, you will see me in the comments. Hearts, claps, prayers, sending love. It was just a magical moment to see justice. After all the things he put the victims through, the judge through, Judge Darrell, oh my God. Y'all about to see. Let's get this started. Let me go to his pretrial hearing where he fired his 2 attorneys and decided to represent himself. Just to let you guys know, on the left is Darrell Brooks in the orange, and in the middle and to the right of him is his 2 attorneys that he fired. To the right of the screen is the 3 attorneys that is taking on this case.
I know that.
I know that.
You have the absolute right to have an attorney represent you. That is protected by the U.S. and the Wisconsin constitutions. Did you hear me say that?
I'm aware of that as well.
We're going to be hearing him say, I'm aware and I'm informed a lot. That is his way of saying that later down the line, he's going to say he didn't understand. She's going to ask a few times, do you understand? He's going to say, I'm aware or I'm informed. It makes no sense. Because I don't care if you're aware or informed, that means you understand, you know? And he just think he's just the smartest man.
You wish to represent yourself.
I wish to represent myself pro per, but I do not wish that my entire Sixth Amendment right not be honored. I essentially would only be agreeing to the part where I want to represent myself.
You either agree or disagree. He want to agree to a part. He want to agree to represent himself, but he don't agree to the rest of it. What kind of sense does that make?
Just that stipulation of my Sixth Amendment and no other stipulation of my Sixth Amendment.
Your Sixth Amendment right to counsel is pretty straightforward, sir. You have the right to an attorney. You have the right to represent yourself. Those 2 things don't always go hand in hand. In fact, never go hand in hand.
Exactly. You either have a right to attorney or you have a right to represent yourself. He wants a right to represent himself, but wants help on the back end. Like he want a sidekick attorney on the side. You can't have your cake and eat it too, which never made sense because if I want my cake, I want to eat it. That's another story.
I understand.
I
I cannot say that this is one of those
Everyone
narrow
said I
class of
understand.
Mr. Brooks.
I
Stop.
object.
See,
Which is
I
my
object.
first.
I never once said I understand. I object. He's trying to play this thing to where word game. I didn't say I understand you about represent myself, but I'm informed. I'm not gonna play the whole hearing. I just wanted y'all to see him wanting to represent himself as well as his attorneys leaving.
Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the
I objected. I didn't
that's the
interrupt. I
procedure
interjected.
that we will
Object.
follow. Perry and Attorney Keys.
Must not.
All right, you may you are discharged and certainly are excused from the remainder of this hearing.
The attorneys are officially discharged, guys.
All right, I know we have a number of outstanding issues. That documentation was provided to Mr. Brooks at the close of the hearing yesterday.
I literally wonder how those 2 attorneys feel, knowing they got discharged from their duties. I really want to be inside their head because they had to deal with him the whole time. I think it took a year. It took about 10 months from the initial appearance of his arrest, him getting an attorney and things like that, and then before trial, because the trial was like the month of the year anniversary. So I just want to know, I just want to get inside their head for a second to wonder how they felt. I'm sure they were relieved. It must be so hard to work with a guy like that. But let's fast forward and get into day 1, guys. Okay, guys, this is day one of the trial. And if you can see, let's see. This is literally, if you can see, you probably can't. It's 28 minutes into the video. I want you to I want you to watch this. No Darrell. Where's Darrell? I wonder where's Darrell. Let's see. We're just 28 minutes until day one. Let's see where he is. Oh my God. Let's fast forward. There he
All right,
is.
we are back on the record. Appearances are as they were before. I need to make a record that at 8:42 a.m. this court ordered Mr. Brooks be removed from the courtroom due to repeated interruptions and disruption with the court. This, of course, comes on the recent history with Mr. Brooks on every day that we have been in court.
Day one, guys, of the trial. There are victims in the audience. There are news people in the audience. Everybody. There are people in the audience. The jury is in the room. Not right now, but eventually the jury does come in. It's a trial going on, and he takes his shirt off.
Shown a complete and utter disrespect for the simple rules of civility. He has been removed from the courtroom multiple times. This morning alone, he started interrupting this court within a minute of the court calling the case.
Within a minute, guys, of the court calling the case, he started his antics and interrupting. Within a minute of a 15-day trial. This is not like a jail courtyard or something like that. This is not a zoo. This is a court where order and decorum is expected. And look at this man.
I should also make a record at the moment he is muted. Because of the way that he was removed from the courtroom and his conduct since. I have been given just a bit of information about it. I will advise everyone that I have required that the Sheriff's Department file a written report with the court regarding Mr. Brooks's conduct. I'm told that he would not sit down while in this courtroom in order to have the shackles removed so that he could be taken to the other courtroom that he.
Let me let y'all know, this is his tactic. His plan is to delay the trial, delay, stall, do anything to stall the inevitable. Oh my God, he had like 25 years on all 6 murders, and then he had like 17 years on top of 7 years of the other 61 counts. So he had like 200 years or 2,000. Who cares? He's in jail for life. So his whole goal was to stall, distract, interrupt, disrupt the whole entire time.
Was resisting. That at one point he took off a shoe, and it appeared to the deputies that he was going to throw the shoe. You can see that he is seated with his back to the court or to the camera. He took his shirt off as well. I'm also told that he is threatening to throw and break items. I want to give him headphones since he has claimed in the past to be hard of hearing. And
his hearing, not his hearing, but his hearing, where he fired his attorney, he complained of being hard of hearing. But if you watch the hearing, he has no headphones on or anything. Later in the trial, he's going to make that an issue, saying he can't hear the judge. He can't hear anything. Suddenly, he's tone deaf. He can't hear anything.
One ear, but given his statement that he would throw and break things, unless he can pledge to this court that he will not do that, I'm not going to provide that information. I will advise that the audio in that courtroom should be turned up accordingly.
Guys, Judge Darrell is the definition of patience, kindness, and decorum. In the beginning, watching this trial, me and along with others in the comments, we were like ticked off because we were like, why is she so patient? Why is she giving him 17 chances to sit down? Why is she giving him 29 chances to stand up? Why is she babying him? Why is she doing? But then as you watch the trial and as you get more context in what's going on, she's literally just doing her job as she should and giving him the right that he has. Unfortunately, everyone has a right to fairness in court, speedy trial, due trial, things like that. And she doesn't want him to appeal for any kind of way on her part. Of course, he does appeal. I think it was denied. I'm not too sure about it. I didn't care after that. But she's just protecting his rights, her rights, and eliminating any reason for appeal, because that's going to be an issue later on. Because of his tactics, he's just trying to get the case thrown out any way he can. So please give her some grace, as I should have done. I think by day 3 or 4 I caught on to why she was so patient, because anybody else, you'll see him in court, I mean, gag him. We want to shock him, doing it, shut him the fuck. But that's what you think. But I understand why she didn't, because that'd be an easier way. Because later you're going to see him accuse the deputies of abusing him. He got a cut, so he needed a band-aid for his cut. Oh, they looked at my cut. I got a boo-boo. I got a band-aid. Anything he could do to stall, he was on it.
So that it is louder than it has been. I've also been advised that the audio and visual equipment is working in that courtroom. The deputies that are in there can see and hear the court through the Polycom system.
Okay, let's continue here.
Other than to indicate that trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula exists for maintaining the appropriate courtroom atmosphere will be best in all situations. And in that,
So as we can see, he's not listening. He's not paying attention to the judge. He can hear the judge. The judge can hear him, but she has him on mute. You can see him pointing, tapping, being aggressive. I guess he's talking to the deputies. That's the only individuals who are in the room with him. In the other courtroom, he got put out for his disruptions. And she's making a record. She's going to do that a lot, just to, like I said, ensure that there's a fair trial. Nothing crazy is going on when it comes to him being disrespected in any way, which I don't agree with. But you clearly see that he is just aggressive right now. He's not getting his way. He's pouting like a 4-year-old child, 5-year-old child that isn't getting their way.
case, there were at least 3 constitutionally permissible ways for a trial judge to handle a stubbornly defiant defendant, which this court would find Mr. Brooks squarely has.
If we were back in medieval times, it would have been off with your head. You know how many people that passed away because they assumed they were a witch, just because I need to get into that too, the Salem witch trial. Just because they could read or write, or it would have been off with his head just for existing. Look at him.
Become and has demonstrated over the course of these last few days. Bind and gag him, I've already talked about at a previous hearing why I choose not to do that. Cite him for contempt, I choose not to do that either. The third is to take him out of the courtroom until he promises to conduct himself properly.
Okay, so bind and gag him, which I am all for and I'm rooting for, but she refused to do. As she previously stated, I understand that. Hold him in contempt, which means that he kind of like goes to jail for acting disorderly. And she doesn't want to do that as well, because that would delay the proceedings, which is what he wants. And I think she knows that he wants to delay. So just holding him in contempt, putting him in jail for like 10 days, is just going to delay the trial by 10 days. So she's not wanting to do that either. So the third option, and she can just remove him from the courtroom, but it won't interrupt his ability to have a fair trial, as he can hear, see, know everything that's going on. He'll be able to hear the witnesses and things like that. If you stay with me during this whole trial, you would definitely see him getting put out the courtroom multiple times. I think it happened at least 15 times. You know, you're going to see him. He's going to act up. He's going to try everything. He's going to accuse his baby mama of still talking to him, because she's like the main witness for the first part of the trial. He's just going to do a lot of things. I just want you to be I don't want to tell it all, but he's going to do a lot of things. So yes, she don't want to bind and gag him. She don't want to hold him in contempt. So she's just going to place him out the room. And it was so frustrating when she let him come back just like that. He was supposed to make an attempt, apologize, and pledge that he would not do anything, But because she's just so worried about appealing and things, she just let him, basically what it seemed like, let him do whatever he wanted to do, in my opinion.
I also was advised by the captain that Mr. Brooks was requesting medical attention.
Look at this buffoon. Look at this bald head buffoon. Oh my God, he sickens me. Just to look at him just sickens me. And like she said, he requested medical for his little sore. He had a oopsie, a boo-boo, whatever. He just sickens me. Look at him.
And reporting a small cut to a finger as a result of when he was removed from this courtroom and taken to the other courtroom.
A small cut to his finger.
I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time, I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done.
Look at him. Look at him. She observed a small cut on his finger. He was seen by medical. They saw no blood. His neck wasn't broke or anything like that. So she's going to proceed, and you saw his reaction.
And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are facing the court. You can see and hear. It's my understanding you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the Sheriff's Department put you in the chair face forward and with shackles on your ankle, as you are in custody, and that is appropriate.
Yes, it is appropriate, because what kind of court trial has the defendant sitting on a chair, sitting on a table, feet in his chair, back turned towards, against the judge, the court, the audience, the cameras, him seeing everything. He can say that, oh, my trial wasn't fair because I couldn't see anything, even though he's the reason he can't see anything. So she's like, you know what? We're going to shackle you to the chair and make you face forward. That sounds like, not the shackling part, but that sounds like a toddler thing. You have to sit here right now, and you have to behave. You have to listen. You have to pay attention. So guys, during this whole trial, he's going to request paperwork, request documentation, and when it's given to him, he's going to deny it. I set for value and return for value this charging document, meaning that he has no parts. He don't care about it. He's not associated with it. He's informed and all those things like that. it's just going to be like a lot of nonsense when it comes to like his documents and his paperwork and things like that. Even the things that he, like I said, he requests, he's going to refuse after requesting them. Just any little thing to delay the proceedings, anything.
Of victims and witnesses, and specifically their faces while they testify.
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
You are correct.
Oh, now he's calm. You already ruled on that. We already agreed that the victim. Shut up. So, guys, we are going to be very familiar with this objection sign during the case when he's thrown out the other room and the jury are being read the charging documents, everything he's been charged for. Sometimes that takes a long time, especially because he got like 76 counts or 67 accounts. 76 counts. It takes a while, like literally a while, like an hour and a half for the judge to read this. And while she's reading the documents to the jury, for some odd reason he chooses to object.
The Wisconsin statutes. The second count of the information in this.
She's on the second count. I think there's 67 accounts and she's on the second one. We're not going to watch all of it. I don't want you to fall asleep on me. I don't want to fall asleep, but I just want to show you his antics.
This case about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
I just want to know, what would you be objecting to exactly? She's reading the charging instruments, the documents of his charges, and he's objecting to his charges. Like, I get it, but I don't get it. No, you're objecting to charges. I mean, if you object, it's just what your charges are. Like, that don't mean that you're guilty, innocent. This is not the stage where the jury is deliberating or anything like that. Just objecting for nothing. He gonna do that so much. Check this out.
41.30 sub 1.
Because it's so many charges, he's getting tired of holding a sign. So let's see what he does.
2 sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The ninth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the.
What do y'all think that means? It looked like he pointed to his stomach. Then he said talking. And then he pointed to the sign. Is his stomach talking? Is he hungry? Is he cranky? Is he saying she talking too much? What do y'all think?
1 sub B of the Wisconsin statutes.
Here he goes.
The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30.
Look how he's standing, and you can clearly see, I can clearly see a small smile as if he feels so accomplished. Look at that small grin he has as if, okay, this gonna work. Okay, this is gonna be the answer. Like, watch this.
A dangerous weapon, contrary to
Look
section 941.30 sub 1, 939.50 sub 3 sub F, and 9.
Okay, I was able to fast forward. I think they went to lunch, if not a small break. And once I press play, you will be able to see that he's actually in the courtroom now. So I started from here so we can both see, because I don't remember. how long it takes for his antics to start up from him being back in the courtroom. So let's see.
The record to reflect that Mr. Brooks is back in the courtroom. Welcome back, Mr. Brooks.
Your Honor, they never asked me during the break because I had so much other stuff going on. I'm not sure. I'm not saying it was intentional on their part, but I was never asked.
They never asked me if I wanted to wear a suit or not. Just to let you know, I wasn't asked, which is a lie because they asked him multiple times before he actually wears a suit eventually. And him wearing a suit is to his benefit, but he's too incompetent to realize it's for his benefit because it removes a small part of bias from the jury and seeing him in jail clothes versus a nice suit. It's in his benefit. But because he's Darrell Brooks and he's a narcissist, he objects and fight that throughout, I think, the first 3 days. And I think day 4, he wears a suit. We're going to see in the future if I'm right or wrong, if you still stay with me. But let's go.
Just want to make that clear for the record.
Thank you. I appreciate that clarification. Nonetheless, I provided you with that opportunity, and here you are. If you want to go to that courtroom, are you waiving your right to be present right now? Your request is denied.
On what basis?
Your request is denied, sir.
So he's only a few minutes into the courtroom before they bring the jury back in. And he's interrupted her like 3 times, 2 times or 3 times. And he also asked to go back in the courtroom, in the other courtroom, because he doesn't like how he's been treated. Let's continue here.
Don't interrupt me. I'm going to continue with these proceedings. Even though you're mild-mannered, even though you're speaking in a soft tone of voice, the conduct still has the same effect. And that's to disrupt, to delay, and to show disrespect for the court proceedings.
It is not. It is not my
Mr.
intent.
Brooks,
It is not
please,
my intent.
I'm not going to force you to sit down.
I forgot to mention day 1, he's very mild-mannered. It's not going to last long. He's condescending. He's pretending he's respecting the proceedings and things like that because his tone is down. It's not going to last long, but he's still failing.
You're welcome to sit down, but I am instructing the jury to come out. You, at your peril, run the risk of me admonishing you in front of them at this.
Also, they did go on a small break. She wasn't finished with the charging documents. So, like I said, it's 67, and she has to read them by law verbally every page. So, they went on a break. The jury's going to come back in, and he's going to disrupt that as well.
This point. I don't want to do that, sir.
I'm seeking to merely understand.
Sir, I cannot give you legal advice. I cannot give you the understanding that...
Clarification, Your Honor. I don't understand what is going on.
He definitely understands what's going on. And if he didn't understand what's going on, he probably should have got a lawyer. Wait, he had 2 lawyers, but he fired both of them. So he definitely understands what's going on.
It's not to be disrespectful. It is not
Mr.
to
Brooks,
prolong the proceedings.
do you understand when I tell you not to interrupt me?
No,
do you
no, I do
understand
not.
when I tell you you need to follow the rules of decorum? I believe you do. Please sit down. The jury's coming in.
With all due respect,
Mr. Brooks, stop talking. It's not appropriate at this point in time. Mr. Brooks, final warning.
Final warning. Day 1.
It must be some clarification.
Mr. Brooks, I want you
It must be some clarification.
Stop.
He know the definition of clarification, but he don't understand what's going on in court. He don't understand, hey, you've been charged with this. The jury is here. I don't care. Even children know what's going on. The jury is here. I'm going to read them the instructions of the trial. How hard is it to grasp? We know he lying.
Interrupting me.
You were quiet. I didn't.
Mr. Brooks, stop talking so I can read through the instructions.
Your Honor, cannot.
Ladies and gentlemen of the jury, I'm going to continue with the jury instructions. I'm on count 38. If you are Mr. Brooks,
Okay, guys, so I fast forward. She is done with those instructions. Like I said, there were like 67. She was on 38, the last clip that you saw. And she is done with those. And so to delay and further cause chaos, he is about to accuse one of the jurors of previously being at one of his hearings and flipping him off and giving him the bird.
I noticed that one of the jurors, the lady in the black that's closest to the screen in that corner chair over there, I recognize her from my initial appearance. She flipped me off coming in to my initial appearance and coming out. I know it's her for a fact. I seen her about like how I'm looking at you right now, so I know for a fact that's her. I don't.
He's accusing this lady of flipping him off before and after the previous hearing that he had. While that is false, and they are going to prove it's false, they're going to have her testify. She's going to deny being there. They're going to do their due diligence because she's one of the jurors, and they're going to verify that she was never there at his initial appearance. Why would a juror be at the initial appearance? It's just so, rare that you're at somebody's appearance, but suddenly you got called to jury duty and all that just opens the door for a lot of more questions. But this is just another way to further delay the process. Now they have to call the witness, have her testify, do those things like that. It's going to be up and shut though. They're going to shut it down real quick though, but it's just an attempt, his desperate attempt to delay even more, delay further.
End up being an issue. Is this some type of way that could be addressed by Your Honor?
Mr. Brooks, you had an opportunity to exercise preemptory strikes and even to question jurors about that. You chose not to. So at this point, any issue you have with that juror is waived.
Okay, you do remember that I was not present in the courtroom. I couldn't see. All I can see from that courtroom in there is just you, Your Honor, and the prosecution's table. I can't even see the bailiffs.
Now, this is the truth. It comes out. He tells the truth for the first time. When he was in the other courtroom, they removed him and everything like that. He was not able to see the juries. They do fix that. They add another monitor and fix that issue in the future when they kick him out. But that is the truth. And let me just add, whether it's the truth or not, let's just say he could see the jurors. He had his back turned anyway. He was having a fit anyway. He was causing chaos anyway. So whether he saw them or not, it doesn't really matter. But like I said, it's just another reason to delay.
So it was no way for me to even see who the jury was. Obviously, I wouldn't know him by name. If I would have been able to see the jurors, I would have immediately addressed that.
So that doesn't mean you get to say anything. It seems to me that the rules don't quite matter. Don't interrupt me. Don't interrupt me.
Did I not just let you read the whole jury instructions and follow the rules that you said I have to write down?
You did.
Anything that I object to.
He does not get a cookie for letting her. He said, didn't I just let you finish the whole entire jury? You're supposed to. That's what you're supposed to do. You don't get a clap, hooray, or any of those.
And hand it in.
Except now that we're discussing them, it seems to me that the rules don't quite matter to you, sir.
No, that is not what's being asserted.
Here's what's happening, sir. I'm telling you, I'm advising you to respect the rules. I'm advising you that if you continue to interrupt.
Okay, right here, these are the three prosecutors that are against Darrell. They for sure do amazing job. The male, his name is Zach Wichow, where he's reading off Mr. Brooks' charges, and he does walk across the table and have Brooks stop talking at one point because he was like literally about to get himself in some hot water. And then the one in the middle is Leslie Baisley. All three of them have a huge part. But the main one is Susan Opper, attorney Opper. She is the GOAT. All three of them are amazing as well. But when Miss Basie has her time, unfortunately you could tell she has like the flu or something. It's that, that's just something I remember because I felt bad for her. But these are the three, and you can see the disdain in Zach's face, how he's trying to hold his emotions back because he's so annoyed. They all three of them have many moments when they're just so fed up with him. They have a couple back and forths. Hopefully I can get it on here for you guys to see in the future. But just pay attention to Zach with y'all. His body language.
I'm advising you that if you continue to interrupt, you risk forfeiting your right to be present in this courtroom.
Are you?
Because I still need to continue with these proceedings, sir. I need to go through all of the documents that you filed, and you're not letting me do that.
Because we didn't
So
get
I'm
past
gonna,
the
if I
issue.
need to, I'll remove you to the other courtroom so that I can do this. And yes, exercise the mute button, sir. And then I'll bring you back when the jury's back.
This was filed, though, Your Honor, and it's a valid.
Mr. Brooks is
valid.
clearly not following the simple rule of civility that I have established.
That's
he
inaccurate,
continues
Your
to
Honor.
interrupt. He's not providing this court with
inaccurate, Your
ability to make rulings on the record without interruption. So this is your final warning, or you will be removed to the other courtroom.
Just to let you know that is not his final warning. She warns him 200 more times throughout this trial.
Will Your Honor honor my First Amendment right?
I'm not answering that question, sir, because I've already addressed it.
So you're making a judicial determination to deprive me of my constitutional
I am not
right.
making any such determination, sir.
So you just said you're not going to answer the question about my First Amendment right, which says
Sir,
that
I've
I have
already
freedom of
answered the
speech.
question that you have a right to present a defense.
That is the
You have a
Sixth
right
Amendment,
to
not
be
the First.
present.
You're trying to twist
You
up the
have
amendments.
a right, Mr. Brooks.
So as you can see, I fast forward and they went on a small break. He is in the other courtroom. Mind you guys, like I said, this is day one. It was a 10-hour live stream. I said 8, but most of them are 8. This one was 10 hours. I have fast forward breaks, fast forward lunch, fast forward pauses, dead time and things like that. So they went on a break to remove him because he would not let her finish. And the whole time you just saw that last clip, the jury was not in the room. So things like that, it delays as well. The jury spent a huge amount of time outside the courtroom because of his antics and things like that.
Able to control his behavior by exercising the mute button, as I have repeatedly throughout these proceedings.
Okay, so now it is time for the opening statement. So she's inviting him back in the courtroom to be able to be involved with that process. And like I said, this is the beginning of her trying to dot her I's and cross her T's to avoid appeal. So she has moments where she will invite him back, even if he doesn't show that he wants to be back, doesn't apologize, doesn't do anything to deserve it. You will see her have moments where she invite him back.
So my question to you is, do you want to come back to this courtroom, sir?
So I can get sent back over here, because as soon as I say something, I'm going to get sent out.
That's not the question she asked. She said yes or no. I'm sorry, I'm moving my mic. I'm speaking about the mic. I'm sorry. That's not the question she asked. She literally asked, do you want to come back? So I can be sent back. And, mind you, he asked to be sent back the first time. But now he's like, so I can be sent back and things like that. That is not what she said.
Mr. Brooks, it's your conduct in this courtroom. It is what dictates the court's response.
You say that even though I never consented to being taken out. You say
He never consented to being taken out. Mind you, he asked. He said, well, just take me in the other courtroom then, since you're not. Just take me in the other courtroom then. But now he's saying, I didn't ask to get out, so why would I? That don't make sense either. I didn't ask to leave, so why would I come back? Like, if you didn't ask to leave, you would want to come back.
you say that everything is about the decorum and all this. That's what you say. But when I'm raising issues of understanding, which I keep telling you I don't understand, then it's looked at as being disruptive. It's looked at as intentionally trying to be disruptive.
As he doing right now. Intentionally. She literally asked. I don't want to repeat myself. Y'all know what's going on. Okay, you see him standing there. I will fast forward a little bit. They had a back and forth where he was just avoiding answering the questions and things like that. So attorney Zach Witchow is going to he's going to start the opening statement regardless if he's there or not. And the opening statement is just a roadmap of telling the jury what to expect throughout the trial and things. So basically he letting them know that he felt like it was intentional, deliberate, and preventable, and things like that. He talked about the parade, the intent, the victims, the evidence the jury would see, and accountability or lack thereof during this whole 15-day debacle, plus the tutor. He never is accountable, apologize, he's going to blame everybody. He's going to blame the vehicle for being recalled. He's going to say he is not Darrell Brooks. He is Darrell Brooks' attorney. And he's just going to deny his name is Darrell Brooks. He don't know that person. He don't go by that name.
All right, at this time, we will give the parties the opportunity to make opening statements. Mr. Brooks is appearing from the other courtroom. That should not influence your verdict in any way, ladies and gentlemen of the jury. Go ahead, Attorney Witchow.
So I'm not going to show you guys the whole opening statement because that's why for the people that don't really watch court and stuff, that might seem boring. It's very interesting to me, but I'm not going to show you the whole thing, but I'm just going to show you a few clips of it, and his behavior.
And he harassed her. And he punched her in the face. And the thing about a swollen eye is it's tough to fake.
Attorney is talking about his ex-girlfriend. He punched her in the eye. He had an argument with her. He sped off and he went during his anger and rage, he went in the direction of the parade and deliberately ran those people over because he was arguing with his ex-girlfriend.
You're going to hear evidence about how after, let me back up. You're going to hear evidence about how the defendant took Erica Patterson all over town that afternoon.
Okay, opening statements are over with. Like I said, he also defined first-degree homicide, reckless endangering safety, and things like that to the jury that are not like lawyers or educated on, definition of certain words and things like that, which I think was well done because, jurors can be anybody. They could work at a warehouse, they could work at Sonic, they could work at McDonald's, and they just called to do jury duty. So he gave a good timeline of what happened before the incident, during the incident, after the incident, and things like that. So let's move forward.
Directly, are you willing to conduct yourself appropriately?
I have conducted myself appropriately.
I'm not.
Are you willing to conduct yourself appropriately? I have conducted myself appropriately. First of all, that's a lie. Second of all, she literally asked for a yes or no answer.
Not asking about your past behavior. I'm asking if you're willing from this point forward, for the purposes of the testimony of two witnesses, to conduct yourself appropriately.
I have.
That's not my question. That's not the answer.
This is crazy, and it's the smallest things that's so hilarious, that she's literally asking a simple question and he's avoiding to give an answer because he's delaying time. Just the smallest thing, he can't answer a simple question. Okay, so this is an officer. This is one of the first witnesses, and what makes this case in this trial so interesting is Darrell Brooks representing himself. So since he representing himself, he has the opportunity by law, to examine all his witnesses and things like that, or all the witnesses in general, the ones that the prosecution called and his own, and cross-examination. But look at listen to the first question he asked this officer, basically to delay, in my opinion.
If you weren't here testifying, that you would have been on duty today? Is it fair to ask that or say that?
Not have been at work today.
So did you feel the testimony that you would be given at trial today warranted you to be in uniform?
Objection, relevance, Your Honor.
Sustained.
So he's accused of mowing down and killing people, but his focus is, why does the cop have his uniform on? If you wasn't testifying, would you be at work? Since you testifying, what led you to wear your uniform? Because that ticks him off to see an officer in uniform testifying, because he's like, why don't you have regular attire on, casual clothes? You come in here in uniform to be a witness. That for some odd reason that bothers him so much, and that's irrelevant, as the prosecution objected to. That is irrelevant to the reason we are here today.
You do not need to answer that, sir. Next question, Mr. Brooks.
Hello guys, welcome back. So I had some technical difficulties going on earlier. So this is going to be the end of part 1. Hopefully it was good enough to reel you guys in, because like I said, I'm going to be doing all 15 days. I'm going to be going through, I went through 10 hours today. I think it was like 45 minutes left. Let's see, I think it was like an hour and 30 minutes left. So I'm going to finish that up tomorrow. And I'm going to do I'm going to finish that tomorrow and then add that to day 2 as well. Plus, I still have to watch, tonight I'm going to watch Stranger Things 3. It's going to be on my Patreon. That's going to be in the comments. And also, I had some body cam footage I was watching as well. I'm trying to get into multiple things, as I said. I have a lot of different niches, as you say, and I have a lot of different interests, and I want to dive into things that I'm not particularly interested in, like Lord of the Rings and things like that. I've never seen it, not even once, never a commercial, trailer, or anything. I'm just team Harry Potter, not saying, people always compare the two, but I'm not saying it's better or worse, because I never experienced it to like say it's better or worse or anything. But I just grew up reading about the Harry Potter books and then got into the movies and things like that. So thank you guys for watching with me. I am gonna add some more things to the end of this video, or just look out for the rest of my video tomorrow or the days after. Thank you guys so much. Thank you. Talk to you later.